Thank you, Mr. Chairman. I want to thank you for holding this hearing to provide an overview of U.S. bankruptcy law and explore avenues for potential reform. I also want to welcome Judge Black from Western Virginia. It includes the 6th District. Judge Black's been a consistent leader in our part of Virginia, and I appreciate having his expertise here today. So I'll start with you, Judge. What benefits have you seen from the Small Business Reorganization Act, which was signed into law in 2019? I was proud to be the lead patron of that. What benefits have you seen for both debtors and creditors since the enactment of Subchapter 5? And do you think those benefits would extend? What do you think the impact would be if the $7.5 million cap were made permanent?
Thank you. With the increase of the debt limit, it would make more small businesses eligible, not only in Southwest Virginia, but across the country. Because as I mentioned earlier, what may be a small business in Southwest Virginia may not, equate to what may be a small business in Los Angeles or elsewhere, where they have higher debt loads. But the other thing is what I have seen in small business cases before me, and I've probably had 30 to 35 of those so far, is the speed with which they're able to get to confirmation and the less fighting and less wheel spinning. I've seen some cases, if they were in a traditional Chapter 11, they'd be on their 3rd or 4th amended disclosure statement, and we'd be 6 or 8 months into the case, and it's just not progressing. The presence of the Subchapter 5 trustee is helping keep the debtors and the creditors on the ball. A lot of these cases are two-party disputes, and if you can bring those parties together and try to eliminate some of the fighting that often goes on in Chapter 11 cases, it keeps the case moving forward. And again, you've got to file a plan within 90 days after the petition date, absent some unusual circumstances. So really, when these cases are filed, debtors' counsel has to be thinking about the plan before they file the case. And so it tends to move a lot faster. We have a higher confirmation rate. And for all of those reasons, I think it's been a great benefit. It's much less expensive. Chapter 11, with a traditional case, it's hard to put, Bob's backhoe into the same reorganization scheme as Circuit City or General Motors. The absolute priority rule, the absence of that and the ability to get a case to confirmation quickly is a real benefit to small businesses. Nobody wants to be in bankruptcy if they can avoid it.
Thank you. I hope the committee can move forward on that issue. I want to shift gears a little bit. Our bankruptcy laws were not written with the biotech and consumer DNA era in mind, which is why I'm proud to join with the gentlelady from California, Congresswoman Lofgren, and others in my Senate colleagues in introducing the Don't Sell My DNA Act, which would explicitly amend the bankruptcy code to add genetic information to the definition of personally identifiable information, require written affirmative consent from individuals before their genetic data can be sold or transferred, and mandate the secure deletion of unsold genetic data. The bill responds directly to the recent bankruptcy filings by 23andMe and recognizes that genetic data, unlike a phone number or email address, is uniquely identifying and permanent, even without a name attached. So Professor Jacoby, if I could ask, how does the bankruptcy system currently treat mass privacy-related claims, particularly those involving genetic data, in terms of classification, priority, and valuation? And are breach victims essentially treated as unsecured tort creditors?
Let me address your last question first. Yes, breach victims, those who experienced the major cybersecurity breach of 23andMe, are treated as general creditors. And in the 23andMe bankruptcy, which the central feature of which was selling the company to a third party, although a related third party as it turns out, the breach claimants will have to turn to any proceeds left in the pot after higher priority creditors get paid. In terms of the broader question that you asked, I will welcome further specific questions, but I would say generally there is a real issue. It needs to be made more clear that applicable non-bankruptcy law must apply here in the bankruptcy context, but also should apply outside of the bankruptcy context. Those should be the same protections in both places.
Given how difficult reputational and identity-related damages are to quantify, should Congress or the courts reconsider how to account for these harms in bankruptcy proceedings, especially in light of the long-term consequences for consumers?
Yes, and I think there is broader thinking to be done outside of bankruptcy in terms of some broader federal level protection.
Thank you. Yield back.
Representative Ben Cline, Republican Virginia, addressed the committee, emphasizing the importance of updating U.S. bankruptcy law to better handle privacy-related claims, especially in the context of genetic data. He introduced the Don't Sell My DNA Act, which would amend the bankruptcy code to include genetic information in the definition of personally identifiable information. This would require companies to obtain written, affirmative consent from individuals before their genetic data can be sold or transferred, and mandate the deletion of unsold genetic data. Representative Cline explained that this bill directly responds to recent bankruptcy filings by companies like 23andMe, which faced criticism over the handling of users' genetic data. He highlighted that unlike a phone number or email address, genetic data is uniquely identifying and permanent, even without a person's name attached. Cline pointed out the gap in current bankruptcy laws, which were not written with the biotech and consumer DNA era in mind, making it difficult to address privacy concerns in cases like 23andMe's bankruptcy filing. Professor Jacoby weighed in on the discussion, stating that in cases of major data breaches, such as the one involving 23andMe, victims are treated as unsecured creditors in the bankruptcy process. He explained that these breach victims would have to rely on whatever proceeds are left after higher priority creditors are paid. Jacoby also stressed the need for clearer regulations on how privacy-related claims, particularly those involving genetic data, are classified and valued in bankruptcy proceedings. Furthermore, he raised the issue of the difficulty in quantifying reputational and identity-related damages, questioning whether Congress or the courts should reconsider how to account for these types of harms in bankruptcy, given the long-term consequences for consumers. He suggested that broader federal protection for consumers' genetic data might be needed outside of the bankruptcy context as well. The conversation ended with Representative Cline urging for stronger protections and a re-evaluation of how privacy breaches are handled, both in bankruptcy law and at the federal level, to safeguard consumers' personal data in the evolving digital age.